Well, good morning, everybody. This is Dr. Sukh Simranjeet Singh, Managing Director for the Strauss Institute and Assistant Dean for Graduate Law Programming at Pepperdine Crusoe School of Law. I'm very pleased to welcome Judge Alexander Williams here with me. Judge Williams, as I've already shared the bio with you, is a phenomenal man, first of all, a great mediator who has served as a judge for many years, also served as a Navy officer, a police officer, an attorney, and he's also a father and a husband. And I'm just pleased to have him here with us. You can look at his longer bio there, but I want to use this time to ask him some questions and get his wisdom to be on this webinar. Judge Williams, welcome.
Good morning, Simran. Thank you very much for inviting me, Dr. Singh. Of course.
Thank you. Would you please give us just a couple of minutes of your history in terms of your professional background, in addition to what I've said, please?
Well, thank you very much. It's been my privilege to be on the earth for almost 80 years. I'm from the state of Virginia in the eastern part of the United States. My mother was the mayor of the city of Richmond, the capital of Virginia, and is still alive at 99. So that's a blessing in my life. However, I've lived in California for all of my adult life, starting with my commitment to the United States Navy. In 1969, I went on to active duty as a naval officer. I might add that between law school and going into the Navy, I had a job for 3 months as a police officer in Virginia Beach, Virginia. And my sole achievement involved wrecking a police car on a railroad track with a train coming. It made front page news. You can see the article over my shoulder there. So my public service career started off badly. But after that, I was on active duty for the Navy as a Navy lawyer, a judge advocate for 5 years, 2 in Long Beach, California, right here in Los Angeles, and 3 at Pearl Harbor, Hawaii. I'm a member of the bar in Virginia, California, and Hawaii. As people know, we do not have one legal system in the United States. We have at least 51 when you count the states and the District of Columbia, and you very often you need to be admitted in different states to practice in them.
Judge,
I'm sorry, go ahead.
No, I just want to point that out. What you just said there is beautiful. You try almost taking us to the basics of U.S. legal system, right, in telling us that we have different jurisdictions within America. And I want to let all our terrific guests here who are delegates from Uganda, sure, and other guests. These are, Judge, these are the highest judicial officers from the country, including the Honorable Chief Justice who's listening to you today. And my request today, and let's just title the presentation, we're going to talk about evolution of alternative or appropriate dispute resolution in the U.S., history and prospects. So we're going to look into, my friends, how ADR evolved in the U.S. as you are trying to evolve, and maybe in a later stage you've already evolved it, but you're trying to strengthen it further, ADR in your own country, wherever you're listening to in this world. I think Judge Williams' prudence and wisdom will help you think through some of the challenges, but some of the opportunities of how ADR developed here in the U.S. Back to you, Judge. Sorry, I interrupted you.
No, that's no interruption at all. I went onto the bench very simply in 1986 and served on the bench for 24 years, the bench being the Los Angeles Superior Court, which is the trial court of highest jurisdiction in our system. And then in 2008, I retired, and since then have served in private practice as a mediator and arbitrator, but actually mediation is all that I do now. It's also been my privilege since about the year 2000, 2002, at that time frame, to be an adjunct professor at Pepperdine teaching the mediation clinic. And I enjoy, very much love my contact with and ongoing work with the Strauss Institute, including what we're doing today.
Thank you, Judge. We are honored to have you here today with us. I have traveled with you to other countries. We have been to India, and I have seen your magic in teaching and training, and I hope we get to take you with us in our next travels to Africa and India, which is going to be in March 2024. In the meantime, In the meantime, I'm going to let you start with this. If you give us a little overview of the history of, let's even start with the US Constitution, or the idea of where does this ADR movement come from? Where does it even originate? That would be very helpful to us, please.
I'm very happy to do that. And it's interesting because I can measure it not only against the history of the United States, but quite frankly, the history of my 50 years of as being a lawyer, 50 plus years of being a lawyer, because I never heard the words alternative dispute resolution used together during the 3 years I was at law school at the University of Virginia, which is a well-regarded law school in my home state of Virginia, where I graduated in 1969. You learned skills, you learned trial skills, you had moot courts for advocacy skills, appellate advocacy skills, but nobody talked about resolution skills. And that came up later in my career. But let's go back and I will tie that in into my own experience. But we start with our Constitution in 1787. The Seventh Amendment provides for the right of trial by jury. And I know that there are a number of countries that have variants of the jury system, but I don't think there's any country that relies on the jury system as much as the United States does. And when I was a lawyer, I was a federal prosecutor, and I handled prosecution of criminal cases in the largest federal district in the United States, the Central District of California, and in fact was the chief assistant in that office, the number 2, to the first woman, I might add, the first woman United States attorney in Los Angeles, and I was her chief assistant there before I went on the bench. The Constitution provides for trial by jury, and in fact, that's what the law was all about. The first voice actually in our history to be heard on the question of the focus of law was, of all people, Abraham Lincoln, who led our country in its most, probably its most damaging war in terms of its impact on us as a country, but also was very famous for his remarks. And several of his remarks have been quoted extensively. And I want to perhaps start off because that voice speaking to us from 150 years ago is a very critical voice in this in the evolution we're talking about. There are 3 quotes from Lincoln, and I'll just go on and, if you don't mind, read them. The first and perhaps most famous reads as follows: discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often, in reality, a loser in terms of fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough. He also said at a different juncture, do not quarrel at all. No man resolved to make the most of himself can spare time for personal contention. Still less can he afford to take all the consequences, including the vitiation of his temper and the loss of self-control. Yield larger things to which you can show no more than equal right, and yield lesser ones, though clearly your own. Better give your path to a dog than be bitten by the dog in contesting for the right. Even killing the dog would not cure the bite. And finally, and perhaps most simply, do I not destroy my enemies when I make them my friends? So that's in the middle of the 19th century was the status of at least Lincoln's opinion. And Lincoln, of course, was an American hero for so many reasons. But he was in the middle of the 19th century, and it wasn't until a later development in the end of the 19th century and the beginning of the 20th century. And that is takes us to the date of 29 August 1906, to the what is referred to as the First Pound Conference. It actually was not named as a conference for Pound, but because Professor Roscoe Pound, then of the Nebraska bar, but later the dean at Harvard, delivered a very famous address at the American Bar Association conference. And in the course of that, his specific complained of two things that he thought were wrong with the American system. And they were, first of all, the emphasis by the courts on procedural form over the substance of human conflict. In other words, what the conflict meant to the individual in terms of how it impacted his or her life was irrelevant. What was relevant is what are the rules of litigation? When do you have to file? If you fail to do so, then you lose. And the fact that you may lose personally as well as legally was simply not considered. This was in 1906. And the title of his speech, by the way, was "The Causes of Popular Dissatisfaction with the Administration of Justice." As a person who lives in a democracy, I'm proud of the fact that this evolution in the law was driven by popular dissatisfaction with the legal system. I think it's important for us as judges to keep an eye out about us in our society, about how the public views what we do, because if they do not see us as just, then we will not have.
May I say one thing here, Judge? What I'm learning so far, which I think is beautiful, is one, you're sharing with us how President Lincoln used his mind, his vision, his ideology to shape the inclusion of dispute resolution and peacemaking into the American legal psyche, if I may. And the other thing I'm hearing from you when you discuss Professor Roscoe Pound is how he also, in many ways, you use the word dissatisfaction with the legal system, is also a man of ideas who used this idea that there has to be a better way, there has to be another way. And you are sharing with us that these basic yet profound ideas of peacemaking has led to where ADR is in the US today. Just wanted to cement that, recap that as to what you're saying so far. Is going very well. Yeah. And I
appreciate that. The President Lincoln, of course, had other things to worry about besides the legal system. And then, of course, he was murdered. His voice was really not heard, but it was remembered. And Professor Pound, on the other hand, really brought a full-on complaint, if you would, but really a resolution to deal with popular discontent, which had been voiced by Lincoln, but Lincoln really had very little time to do anything about it. And in his speech, not only did he object to and stress the public's dissatisfaction with the fact that procedural form overrode the question of justice, but secondly, there was something that he referred to as the sporting theory of justice, the notion that litigation is a game to be won by a lawyer combatants. And because it ignored the needs of the parties themselves as opposed to the legal positions thereof, and it caused low regard for the court system. And there was no immediate revolution. However, in that same room, at that same lectern in 1976, this is it is more than a half century after Pound's famous speech. There was a national conference on the causes of popular dissatisfaction with the administration of justice. That was called the Pound Conference. That title was specifically adopted by by this so-called Pound Conference to echo the words of Pound's own words in entitling his speech of so many decades prior, back in 1906. That conference, importantly, was convened by the Chief Justice of the United States. And one of the things about Chief Justice Warrenberger is that he felt that as the Chief Justice, he wasn't just the Chief Justice of the United States Supreme Court. He was the Chief Justice of the United States. And you will see to this day that Chief Justices proudly have themselves identified not simply as the leading judicial officer on a specific court, but as the leading judicial officer of the nation. And I think that gave him a sense of the importance of judicial reform. And as we speak with people around the world, as we are doing today, Professor Singh, I would make that note that leadership, once judges accept the fact and can establish the fact that they are leaders in their community, they can do many things to make things happen better for people around us. And sometimes the insularity of the bench causes us to lose sight of that. So one of the things I love talking about when I have the privilege of addressing judges and justices, and particularly chief justices, is to invite them to note that although American history is by no means a perfect story, there is a lot of evidence of the leadership capability of judges in shaping the quality of legal life in the United States. Chief Justice Burger used the phrase healers of conflict. He noted that doctors are healers, medical healers, and why shouldn't lawyers be healers of conflicts? He is quoted as saying, "Our system is too costly, too painful, too destructive, too efficient for truly civilized people. To rely on the adversary process as the principal means of resolving conflict is a mistake that must be corrected." Now, this is this is a speech after the Pound Conference, showing that the Chief Justice had picked up this torch and was carrying it forward. He had convened the Pound Conference in 1976. Professor Frank Sander of Harvard spoke at the Pound Conference, and he inaugurated a notion that exists today and that I like very much, and that I commend to my colleagues as judicial officers wherever I find them. And that is the concept of a multi-doored courthouse. The idea that a courthouse should be a justice center with different processes available, different systems available for purposes of meeting the needs of the public. And he carried through in 1984, as I noted earlier, in his speech to the American Bar Association.
If I may now, Judge Williams, so from Justice Burger, who I love that you said is Chief Justice of the United States, not just the Supreme Court. I love that clarification. Yes. And the quote you mentioned, that our system is too costly, too painful, too destructive. To moving on to Frank Sander for multi-door courthouse. Let's just pause here for the multi-door courthouse. It may be a new term for some of our friends. Would you explain to us what is a multi-door courthouse? And did the concept start right here with this discussion you're having? Or was it a reminder to American public of what it has been from the past?
I think that specific image was specific to Professor Sander, and I note that I took a course from Professor Sander shortly before he passed away.
Wow.
I remember that a distinctive feature of his class was that he invited the entire class to tea in his home, which is something you don't see a lot on campuses these days. It was a wonderful experience. The concept of meeting the public's needs was not new, but the image of the multi-doored courthouse, I think, it concretizes it. It gives us a sense of how we as judges can do things. And that means let's build a courthouse that can give you small claims court, which has very simple procedures and a very quick remedy, although not in a big case. The middle-sized cases, the longer or large-sized cases, the complex cases, but also options such as arbitration or settlement conferences by judges, which was a judicial form of mediation, and although it is different under California law from mediation, settlement conferences have a little different legal impact. It is a very common way that judges can choose, if they wish to personally come into the justice system and reach past the conflict to see if they can help resolve it. I studied at that mediation workshop at Harvard, and I was a judge at the time, and I carried back a sense of, I want to learn more about this. Now, that was before I had any exposure to Pepperdine, and Pepperdine is what really changed my life in terms of my experience as a judge. In fact, my presiding judge was not happy when he read the profile of me in the Daily Journal, and I noted that I had not tried a case in a year and a half. And the reason I had not tried a case in a year and a half is I'd settled them all. And he didn't regard that as a good thing. He thought as a judge, we try cases, and that was the metric that he used to measure how we do our job. And of course, in a large county like Los Angeles, you have to remember the presiding judge has the power to transfer you to a very distant location if he or she wishes to. We refer to that as freeway therapy on the court. And so I was not happy to hear that he wasn't happy to hear that I had been settling cases. However, within about 10 years, a very different presiding judge, taking note of the fact of my interest, my training at Pepperdine and at Harvard, and my success in settling cases, asked me to serve full-time as a settlement judge. And my last 3 years on the bench, I was doing settlement conference after settlement conference after settlement conference. And as my clerk said, I was there at midnight settling cases for judges who went home at 2:30 in the afternoon.
There you go. Can I, this is a great, would you please share with us the difference, since you did settlement conferences and now you are a full-time mediator, a neutral judge, what's the key difference, if there is any, between a settlement conference, at least as you understand? I know there are different kinds of settlement conferences within the United States, but for our guests here, what's the key difference between a settlement conference that's run by a judge versus being a mediator?
I think in one word, authority. Because as a settlement judge, you are a judge. Even if I tried to let people know that the judicial involvement was going to be towards the lines of making peace as opposed to regulating the fight, it makes a difference. What I would do is I would, when I was doing settlement conferences, I would greet people in the courtroom with my robe on. I would escort all sides, because I had started with, and when I was doing settlement conferences, I wanted everybody to hear everything at the beginning about what it was and what the process was. But as soon as I ushered them into my jury room, which was the only room I had big enough to be able to speak to all of the parties and interested people in the conference, I would take the robe off and hang it up as a symbol of saying, now at this point, this becomes a settlement conference. You have the right not to say anything at all. You have the right to disregard what's going on. This is a voluntary service offered by the court. But why don't you see what we can do about settling this case? And even though I'd taken the robe off, I'm not a blushing violet, Dr. Singh, as you probably know. I certainly, I was a judicial presence of some note within that room. And hopefully I had the personality and the commitment and the values to convey quickly to everybody there, so they took comfort in being there. And that was, and I learned that, and I perfected that, I hope, or at least developed it at Pepperdine. Harvard will teach you everything about it, but Pepperdine is the place that'll teach you how to do it. And that's a very distinct, very big difference.
Thank you, Judge.
So I think the difference is authority. I have no such authority in a private mediation, although they are mindful of the fact that I had a reputation of being a pretty strong judge. Mm-hmm. So I suspect that the echoes of my judicial life are still present, but legally I have no authority. The challenge is to guide them along by helping them make decision after decision until the final decision is made in the case.
This is very helpful. The main summary, if I may say, is the judge, and being the judge, the authority that comes with it. But as a mediator, our job is to facilitate, and perhaps the authority lies with the parties. So
absolutely, thank you. You've said it even better than I did.
No, thank you, Judge.
It's all about the authority. And as you noted at the beginning of our conversation here today, ADR has come to mean not just alternative dispute resolution, but appropriate dispute resolution, what's appropriate for the case. And I like to say that there are both client-based reasons, but also court-based reasons that mediation or settlement can be of value. And I'd really like to commend that to my judicial colleagues that we're speaking to today. In terms of the personal client reasons for settling, you can save time, money, risk, dignity, stress, and in fact, relationships. You get to save all of those things, and you get, and I enjoyed making this one alliterative, you get choice, control, certainty, confidentiality, creativity, and closure. So those are values that we offer to the public when we participate in or otherwise generate alternative dispute resolution. I might add that there are court-based reasons for it, and then we'll talk about one of the questions that the judges face. But the court-based reasons, I think, are simply, first of all, judicial economy. If I settle a case in a day instead of trying it for a week or two, that is a saving not just for me and my judicial time. I don't play golf. If I've settled a case, it's on to the next one. It provides, it also, in addition to judicial economy, you don't need the jurors, you don't need the lawyers get to save time. It's a huge saving. It's also about access to justice. There are some cases that have to be tried, and it is better that those cases are in a courtroom that gets rid of, or at least helps resolve, cases that may not need to be tried, that can be saved. And so I found that if I did have to try a case, the decks were clear to be able to try it. And of course, that's the best settlement device going. If you tell lawyers that you're going to have a jury there in about the next 15 minutes, it's amazing how quickly they can settle a case. The patter of jurors' feet coming down the hallway is a magical sound in the life of a judge.
We both know not every jurisdiction in the world has jury system, though. So that itself is a unique part of American legal system, is the jury system. Yes,
it is indeed. But anyway, if you have an open court, even if it's not a jury and not about a jury, said, oh, Judge so-and-so down the hall is ready for you. Just go on down and get started. It's amazing how many cases get settled on that walk down to the other courthouse. Certainty breeds closure. And the quality of justice, because I think most of us believe if people can participate in shaping their result, as opposed to sitting back and letting the court dictate a result, they're going to have a better quality of justice and more customer satisfaction. Remember, customer satisfaction, in a way, was what got the Pound Initiative started in the first place, what the public felt. Now, of course, in the United States today, it has evolved. We have private arbitration, private mediation, neutral evaluation, all kinds of devices. And then you have court-connected programs where the court doesn't conduct the mediation but in fact will provide for a panel. Most of the mediators here in Los Angeles who are of my generation, who were not judges, and there are many fine mediators who were not judges, commenced their career as volunteers on court panels at the LA Superior Court or at the federal court. And the volunteers are usually very good people, very good settlers, because they practice in the field. They know the value of a case. And so therefore, the questions for judges, I think, are the following. Mm-hmm. Do you as a judge, or do you as a court want to encourage ADR? I certainly hope so. Do you want to mandate or require alternative dispute resolution? There are some programs that do that. However, there are many people who are students of mediation who say, if it's voluntary, that means it's voluntary, and you can't and should not force it. But there are some courts that do. Do you want to go further and provide ADR? Have panels, generate a panel on the Superior Court of lawyers who you can refer cases to. And finally, do you want to actually conduct ADR? And of course, the answer for me as a judge was yes, 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 and yes for all four of those questions. But remember, a court can be supportive of dispute alternative or appropriate dispute resolution without doing it themselves. I don't want judges because it's not everybody's cup of tea, if I can use that expression.
Yeah. Yeah. Can I repeat just what you said, Judge? This is very good questions. Do you want to encourage ADR?
Yeah.
Do you want to mandate or require ADR?
Right.
Do you want to provide ADR to superior court? And
through panels, like setting up a panel.
And the last one was, do you want to
personally conduct it as a judge?
Personally conduct as a judge.
Yeah. And that's it's interesting that I think the general legal culture recognizes, although I don't have a way to put my finger on an authority for it, that while a judge can be assigned to try cases, assigned to rule on motions, decide legal issues, that a judge should not be assigned to do settlement work unless that's something he or she wants to do, because it is not yet recognized, and nor do I think it needs to be recognized as a judicial requirement. There are judges who are terrific settlement judges of all types and backgrounds, but there are many who are terrific trial judges and really do not aspire to be, and quite frankly would be the first to agree that they would not be particularly drawn to or good at that. So I don't want our audience, the people we have the privilege to talk to feel like you have to go all the way to sitting down and trying to settle cases yourself as a judge. It is a difficult transition. There are distinctions between the art of judging and the art of settling, but you can go a long way toward encouraging it without going that far if you don't want to.
Thank you.
And that's responsive to, I have actually been in Africa, believe it or not, in Nigeria a number of years ago with Peter Robinson, our colleague at Pepperdine. And in fact, by the way, there was a judge from Uganda there as a guest, and I regret that I don't have my notes. I cannot remember his name. He was a remarkable man. He was very articulate on this topic, and if I can find his name in my notes, I will let you know. That was a good 10 to 15 years ago, like 2006 when we went there.
That's amazing. Judge, quick question. Do court-connected ADR programs, by your estimate, do most courts in the U.S. have some kind of court-connected ADR program?
Yes, they do now. They did not necessarily when I was on the bench. Some of it was legislated. For instance, I believe in California, there was a decision or a rule that was either enacted by the court or by the legislature that required the Superior Court in each county, and there's 50-some counties in in the state of California, to require each county's Superior Court to create a panel of mediators who could be of service. And that has become, I think almost any court now will have such a panel. In fact, I routinely recommend to my students who come to Pepperdine and want to know how does one generate an ability or generate an opportunity to do this for a living, I recommend to them is wherever you go, look to your local courts, because the courts, based upon the history that we've been talking about here this morning, are very active in this field. It will be very unusual to find a court that doesn't have an ADR coordinator of some stature and an ADR panel. And that's a place to volunteer, because and that's how you build your skills, and it's also how you build your contacts in the community who will seek you out.
Judge, what role did bar associations play around the same time? Were the bar associations inactive, active, jealous, supportive? Where were they?
They were certainly not jealous. They wanted opportunities for their lawyers. Can't put my finger on a specific program at the time when I was getting started, but I can tell you now that both the Los Angeles County Bar Association and the Beverly Hills Bar Association regularly sponsor presentations that meet mandatory continuing legal education, MCLE requirements. and they are in the field of often in the field of dispute resolution, including arbitration, mediation. Some of them are presented by mediators. I presented on panels involving everything from the county bar. I've taken programs from the Beverly Hills Bar, which is very active in this field. So to the extent that I have personal experience or knowledge, it is a very active support, depending upon the size of the bar and the interest of the bar.
Thank you, Judge.
But that's a good point, because I think if a court decides that they want to go down this road, or I would rather say up this road, because I think it's a matter of progress to enhance ADR in their community. My expectation would be that the bar would be very enthusiastic. In fact, one of your speakers that you and I heard speak recently, and forgive me for forgetting his name,
Mr. Singhvi from India.
Exactly. He talked about how there was a particularly active group of lawyers in the city of Agra.
Mm-hmm.
And of course, I happen to know, because if I open my phone, I'll show you a picture of my wife and me at the Taj Mahal, which is in Agra.
Agra, yes.
And of course, I'm not surprised to see that people are enthusiastic and warm about progressive settlement work if they live in a place with that memorial to love and affection and respect.
And I see Judge Bar as an important part of stakeholders for promotion of dispute resolution as we are focusing on judiciary. And then I also see education or law professors as one, lawyers, generally speaking, as one, not the leadership of bar, the lawyers who have to follow the act, and then the clients, the general public. Right. So excellent point. Thank you, Judge.
Well, actually, it's your point, and I think I agree with you. It's an excellent point. So then I think that leads us to the kinds of questions that exist presently that we might want to talk about. And I have about a list of a number. What I'd like to do is just sort of recite them slowly, and let's contemplate what we might want to do with respect to the future of ADR. I think we have to be concerned about affordability, the question of certification, the issue of diversity. It's largely a bunch of boys right now, although actually, quite frankly, the number of women is impressive. And in fact, the company that I work for was founded by a non-lawyer woman, Lucy Barron, here in Los Angeles. Diversity, the question of growth, licensing. There's no requirement to be licensed as a mediator in California. It is much harder to be a cosmetologist, a beautician, than it is to be a mediator. All you have to do is do it. Evidence Code 1115 says a mediator is somebody who tries to help other people resolve a dispute. Do we want to mandate it? Does that defeat the spirit of mediation, that it's voluntariness? That's a dilemma that we have to deal with. My view as a judge is I would push hard, but in the end would respect choice. I had a speech already, though. I said, well, counsel, if you don't want to go to mediation, I guess you're telling me that you wake up every day rejoicing in the stress, expense, delay, frustration, and consumption of time that is involved in this lawsuit. And he would laugh, or she would laugh, and they would agree to go to mediation. So there are ways to persuade, but there are other questions. Qualifications. If we don't have a licensing program, how's the public protected against some charlatan who tries to tell them what to do? And we run into people like that even at our small claims. As you know, we're very active sending students into small claims court to mediate cases. And in that environment, there are all kinds of folks walking up and down the hall offering all kinds of services. Do we want to require it? Do you have to? And do we want to acknowledge specialization? Now we're getting inquiries routinely at ADR services where I work, searching for a mediator who's familiar with a particular fairly narrow field. Anybody here dealt with this type of case or that type of case? And how do we handle that? The whole question of Zoom revolutionized this business. Until the pandemic shut us down, everything we did was live, either at ADR services or in person. Sometimes sometimes I would do a mediation at the location if that was the center of the dispute, or the house that might be, or the yard, or parking lot. One time we walked a parking lot as part of a settlement process. Excuse me, I'm sorry, I'm losing my voice. So we look to that in terms of what the prospects may be. I'm happy to discuss any of those topics.
Yeah, I think that's just, let's start with the idea of certification. Okay. Because our friends in other countries may think about, should there be a certification for media? I have heard from a speaker from Singapore recently who is adamant, and he thinks certification is mandatory. There is, but then I have seen the best of mediators who are not certified, and they've taken a training or two, but this is a natural art. I've seen people who are naturally good at this. Do you fear that if we have a very stringent certification that will remove the opportunity from some very deserving men and women? Or do you feel like certification will add a more prestige to the process of who a mediator is?
I'm going to answer the question, yes. and by that, I mean, number one, I think that we need some baseline public protection in this like other fields. And I'm not surprised that the Singapore representative took such a stringent. I'm very fond of Singapore. I love the fact that when I visited there last, they had little signs on the buses that said, remember, low crime is still not no crime. I'm very impressed with Singapore. I think all of us are. However, I also am worried about access and opportunity, and I think that perhaps a certification program might be better. A certification option where a mediator can choose to meet those requirements, because that will give people a sense, if the people want to offer it, of reliability, of value, of quality control. However, we also have done very, very well with not having any kind of qualification requirements. Now, having said that, the flip side of that coin may well be how expensive it has become, and at least how much you and I have both attended presentations recently where the mediators have talked about what's being paid to some people, particularly retired federal judges who have demonstrated some ability in settlement work. So there's an interrelationship. I would like to see, I think we should offer certification. I'm not sure we should require it.
Thank you. Thank you. And maybe that's connected to the idea of specialization you brought up. Perhaps certification can be for specialists, right?
Exactly. That's another option. Yeah. If you're going to call yourself a specialist, then you have to establish your right to do so. And that is, by the way the bar talks about recognized legal specialists. There are people who can identify themselves in California as a legal specialist in criminal law and in other types of law, and you can't do that without the support of the legal system that provides for it.
Please help us with the idea of mandatoriness, the idea that mediation should be mandatory. What does that even mean? Does it mean parties attempt if a judge refers the case, or does it mean they have to complete? Just a simple distinction.
Well, that it may be simple, but it goes to the heart of it. Nobody wants a system where you are required to settle your case. The Constitution provides the constitutionally prescribed dispute resolution methodology of the courts, and the courts are constantly trying to evolve to make it a better, fairer, less expensive process. It may not look like that, but that's I think that's at its heart. That's the mission of the courts. At the same time, people need a shove, and I remember a lawyer one time saying, you know, Judge, I know you're going to try to send me to mediation, and I'm a mediator myself, and I really respect your work, but please don't send us out because this case, I can guarantee you, is not going to settle. And I smiled and I said, you are a marvelous mediator. Let's give people a choice. And sure enough, he came back and about 2 months later told us the case had settled because it had in fact gone to mediation because I'd given him that shove. Now, that's not universal, nor is it desirable. I don't want to be pushing lawyers around and telling them what to do. They know their cases. They're the experts about their cases. Every case that I deal with, Dr. Singh, I am a Johnny-come-lately to the conversation. Everybody else there knows more than I do, and I have to modestly acknowledge and recognize that, or I will be of no value to them at all.
Well, Judge, what a phenomenal discussion today. I know this is the beginning of our discussion, not the end. We started laying out these beautiful core concepts of how ADR actually evolved here in the United States. And I don't think I could have had a better speaker than you. Speaking from the bottom of my heart, seriously, you have really given us terrific insight into some of the founding fathers of, if you may, ADR movement here in the country. If I take you back there to that idea of starting of ADR movement, anything else you want to add before we close our presentation today? This has been very helpful. Thank you.
Well, thank you. You're very kind, and as you know, I love working with you. And I thank you for when you acknowledged that we'd been to India together. You didn't mention the fact that I managed to leave our suitcases at the hotel one day. So I appreciate that. On the other hand, I'm still looking for that security detail that I talked to you about in Amritsar. And anyway,
you managed to left the suitcases, and then you managed to upgrade everybody's flight to first class. So everybody got a good, that was very nice of you.
It worked out very well. And then we got swept away to a wedding with 10,000 people.
Yes.
It was marvelous.
It was a joy to take you to India, Judge. I really hope we make it happen again, and also to Africa, that I take you to Uganda. And I know you have a standing invite from the Chief Justice and others, and I would like you to consider it strongly.
Well, I would be honored to be invited and delighted to participate in anything of that order. You know, we all want to be able to do things when the hair colors turns to mine, and I really love what I do at Pepperdine, particularly because Pepperdine is universal in its reach, and that reach also includes not requiring, recognize that mediators may not need to be lawyers.
Yes.
In specialized fields. So I think all of that's important. As I look back on it, I have loved everything I've ever done. I've just been very fortunate every job. I loved wearing my country's uniform as a naval officer. I sort of enjoyed the police job, although I'll be forever famous. By the way, the guy hit me. I didn't hit him, but that no one will accept that, and it certainly didn't look like it from the picture. I have loved everything I've done. I've loved representing the United States of America as a United States attorney, and I have loved being a judge on the Superior Court of the County of Los Angeles for 24 years. I have loved, and I've loved working at Strauss, and that love has extended to the fact that I met my wife in court. In my court, she was a court interpreter assigned to work in my courtroom, and that's where it started. So I not only, you could say I've not only practiced in court, I've married in court essentially, and then one of my colleagues actually presided over the wedding. Anyway, Judge, it's a wonderful thing to do, and it's wonderful work done by very nice people.
Well, thank you so much, Judge. This was a phenomenal, close to an hour talk, and I really thank you again, and I look forward to doing more of these presentations with you. I really wish you a good day today. Again, thank you on behalf of all the listeners. Thank you, Judge, for your very, very helpful, in-depth conversation on this very important topic.
Thank you, Dr. Singh. It was a pleasure.
Thank you, Judge.